Good morning. This is May's episode of The Flip Side. Today I have the honor of introducing Cary Jacobson of Jacobson Family Law. We're going to discuss divorce, some misconceptions about prenuptial and postnuptial agreements. We're going to talk about adoption and just in general what a family law attorney does. Speaking for myself, I always equated family law attorneys with just divorce. And as Cary shared with me, there's so much more they do. So with that in mind, I'm going to turn it over to Cary. Cary, would you mind telling us a little about you, your practice, and just an overview of what you do?
Sure. So my name is Cary Jacobson. I own the Jacobson Family Law. I am a solo practitioner in Howard County. I primarily handle family law matters, which include a scope of things from divorce to child custody, modification actions, child support, and contempt actions. So anything that's like post-judgment enforcement actions and that sort of thing. I also do some mediation when parties are coming to try to work out an agreement between the two of them. I can mediate cases and help them find a resolution.
Awesome. When I was active duty, unfortunately, I would see a lot of people go through divorce. And it became very, very ugly. And I don't think it necessarily had to, where they're dragging their kids to court and then their children had to get an attorney. I mean, it just seemed to get really horrible. Are there some alternatives? I think you said mediation was an alternative. Could you elaborate a little more?
Absolutely. So there's multiple ways to reach a resolution in a family law case, whether it's a custody case or a divorce action. And honestly, the courts very much encourage parties to reach an agreement or a settlement. And that can be done prior to the case ever making its way to court, where parties will come into mediation or some other practice in order to resolve the matter. Oftentimes I'm asked to prepare a separation agreement, and the parties may just resolve their issues by way of a separation agreement, which is a contract between the two of them. If it's an action that goes to court, the courts actually promote and will order the parties to go to mediation if it's related to a custody action. So they are very much promoting and wanting the parties to settle because they believe, and the research shows, that parties who reach a resolution on their own without having to go to court are more likely to abide by that agreement.
And it's a little more friendly to the wallet, I would think, too, because you're not paying the attorney to be in court litigating and all that extra time, correct?
Correct. So a case can resolve itself anywhere from prior to the case being filed all the way to the day of court. And it is not uncommon, unfortunately, to get to trial and even have sometimes judges say, can't you work this out? Because a lot of times the judges simply don't want to be the ones to make a ruling on a case. And unfortunately, in those situations, you have spent a lot of money and time getting to trial. But ultimately, I think even if it's on the courthouse steps, reaching a resolution is often better than what a judge may do.
So just to clarify what I heard, make sure I heard it correctly, you could try to mediate, it may not work, or you may decide to go to before the judge because you feel like you just can't talk to this other individual. You get in front of the judge, and the judge could still turn around and say, nope, I'm not going to hear it, you need to go mediate.
It depends on the judge. And many attorneys will tell you it always depends on the judge. But I have had a case that actually we started testimony, and before the judge gave a ruling said, do you want to talk with one another? So it is not uncommon. And ultimately the parties did reach a resolution before the judge made a ruling. So it does happen.
Wow. So, and that's a good segue, because now that the divorce is over, or perhaps before you get to a divorce, the prenuptial agreements and postnuptial agreements, I always thought they're for the rich. But in doing some research and talking with you, it's come out that especially I work with a lot of families with disabilities, and it seems like a prenuptial agreement may be a very, very good resource, not because you're expecting a divorce, but to protect that child those assets to the child? Because if you don't have a prenuptial agreement, then the spouse is entitled to 50% or so, right?
So typically, Maryland is considered to be an equitable distribution state. So the court has to take into account many different factors when doing a property division if the case were to go before a judge for a divorce. Starting place, most commonly, the judge will do a division on a 50-50 grounds, but it doesn't have to be. I find that many people come in to me for prenuptial agreements if one of the parties has more assets than another. But oftentimes, many people are coming to me because they have already gone through a divorce and they know how terrible they can be. And so they want to prevent that going into, to a new marriage and want to know what the outcome will be. So they outline how the assets would be distributed in the event of a divorce. And it also can deal with how the children will be taken care of, how expenses will be shared, what right either party may have to assets in the event of a death as well. So I am finding more and more so that a lot of blended families, second marriages, etc., will do prenuptial agreements.
And then for those that aren't, maybe they're in their first marriage, but the honeymoon phase is worn off. Now they've been married for 2 or 3 years. Again, I don't want to focus on the fact that they're thinking that they're going to divorce. But I mean, I'm a big believer in managing risk, mitigating risk. And I think a postnuptial agreement could mitigate that risk that you can't predict 10, 15, 20 years down the road what's going to happen. So is a postnuptial agreement really like the same thing as a prenuptial, or is there any differences?
No, there's really no difference other than the timing in which it's signed. And so it's really just an outline of what would happen in the event of a dissolution of a marriage in the future. Similarly, the same thing with a separation agreement, only it's the timing as far as now the separation and divorce is happening or is expected to happen immediately. And so people are, again, just determining how the assets are going to be divided. So they're all contracts that outline how assets are going to be divided, what obligations, what expenses, what debts may be, how those may be divided. Okay.
So, and I'm just going to ask one more question about divorce. I'm going to get into something a little happier with the adoption. Is it, when I was active duty, I was always told, I think everybody was told, it was just kind of an urban legend, if you will, that if you got divorced, your spouse was entitled to 50% of your pension and 50% of any assets you had. So we had a saying, right, wrong, or indifferent, that it was cheaper to keep her. So is that true? Is it an automatic that you're going to have to give 50% of your pension up and you have to get life insurance or what have you? Or
so nothing is automatic. There are things that the law provides, and in Maryland, it is typically the case that it's 50% of the marital share of assets that are earned during the term of the marriage. And that goes for both parties. So it doesn't matter which spouse has earned it and in whose name it is in. So each party is entitled to that division. That being said, in an agreement, parties can do whatever they want to. And I have had multiple cases where the parties have waived any right they may have to retirement for various reasons. It could simply be they don't want to go through the expense of litigation. They don't want to go through the emotional toll that it may be, or they may be getting something in exchange. So, people barter all the time. So maybe one party gets the house in exchange for their share of the pension. So it just varies on a case-by-case basis as to how people will handle that.
So what I heard you say there, I heard you say whatever was earned in the marriage. Is an inheritance earned, or is that, so if you have a spouse that inherits, from their grandmother, $50,000, does that become marital property, or is that the spouse's?
There are three exceptions to what the definition of marital property. One is assets that are received by inheritance. So as long as someone receives the funds from inheritance and they are kept separate, and that spouse doesn't commingle those assets with marital property, then the inheritance should be protected. But
So,
as with everything, it depends.
So I mean, don't put it in a joint account, right? If a spouse gets it, they should open up an account in their name. I mean, they can make the spouse beneficiary, but it wouldn't be a joint account.
Correct. So that would be the recommendation, and not to put any further marital assets into that account. So you don't want to put your income or your paycheck in there. But if you were to receive a second inheritance, that could be commingled.
Okay.
Again,
like, this isn't, and I really don't want people thinking that I think everybody that gets married is getting a divorce. I would rather, I seem to see a lot of people that are older in their 50s, 60s getting divorces now. And it just highlights the fact you can't predict what's going to happen after 15, 20 years.
Correct.
So let's talk about something a little happier. Adoptions. This is not an area I'm very familiar with, but it does make sense that you would need an attorney to work with you, because it seems like this is a very convoluted system. And those are my words.
Right. So it is recommended. I do not do the independent adoptions. So there are different types of adoptions. There's independent adoptions. There are adoptions where you are adopting from a agency. And then there are step-parent adoptions. So where two spouses are now married, the step-parent wants to adopt the one of the spouse's child, and so there are different procedures for each of them, and so there really are attorneys who concentrate in those areas, because there are so many different rules associated with the practice. And so you really need to have an attorney that does that on a day in, day out basis, because it is so specialized, such a specialized area. And again, each county, each venue has their own practices with what they are looking for. So if someone is looking to do an adoption, I would highly recommend that you find an attorney that concentrates in that area.
If somebody didn't know where to look, could they reach out to you? I mean, do you have resources that you could refer them to?
Absolutely. And there's also multiple attorney directories online these days. FindLaw or AVVO. You can usually do a search by the city or county that you're in and find an attorney that concentrates in that specific area.
Awesome. So if somebody wanted to work with you, your concentration is more of the collaborative divorce and mediation, correct?
So I am a certified collaborative divorce attorney. I am also a certified mediator, but I also handle, actual litigation. I do my best to get those cases to resolve, and most of them do. But in the event that they can't be, I do litigation as well. I prepare separation agreements. I handle all of the facets of family law.
So just for the listeners and the viewers that aren't as familiar, litigation is basically you go to court, right? You say you will speak up on behalf of whoever retains you before the judge and the opposing counsel, right?
Correct. So a litigated case is where ultimately you are asking the judge to make the final decision because you and the other party are unable to reach an agreement on your own.
Okay. And then the difference between mediation and collaboration, could you just go over that a little bit?
Yes. So collaborative divorce is a unique process whereby both parties are represented by attorneys who have been collaboratively trained. Oftentimes there is a mental health professional that would work with the parties in creating a parenting plan, how the parties are going to share time with their children and communicate with one another. Also, there is typically a financial neutral, someone who's going to work with the parties in looking at their budgets, looking at the assets that they have, and crafting a way that's going to be most beneficial for the family to divide those assets and what support should be paid from one spouse to another. the unique process with regards to the collaboration is that all of the parties, that team, with the individuals that I just spoke of, would sign an agreement, a contract, saying that in the event the collaborative process broke down, that the parties now have to get new attorneys to go to litigation. And the purpose behind that is so that neither party can hang litigation over the other person's head to say, well, I'm just going to walk out. It makes them both have to really buy into the process. And for the most part, parties do, and they can be very successful. Mediation is where two parties, sometimes represented by a counsel and most of the time not, will sit down with a mediator to facilitate a discussion in trying to help them reach a resolution. Sometimes the mediator may recommend that there be other outside sources, so that the parties may go to, their own attorneys, or may go to a financial neutral to work out some of those issues. But usually with mediation, it's just the parties with the mediator trying to facilitate a discussion.
Awesome. Thank you. Is there anything I should have asked that I didn't? Anything that you'd like to add?
Ultimately, I think it's really that litigation should be the last resort, because you never know what a judge may do. A judge doesn't necessarily know your family and your circumstances, and the amount of time that you get to sit before a judge and to give them the information that is related to your life is going to be, mere hours. And to allow someone who doesn't know you or your family to come in and make a decision about what's going to happen going forward, in my mind, is not always the best idea. But unfortunately, sometimes that has to be the way that it is, because you can't always reach a resolution with the other side.
Sure, because both to reach that agreement. So one last thought: if you're going before a judge, I would think that, and I mean, this is a layperson talking, but I would just think that it would take so incredibly long to get through that process, because judges probably have just so many people that they have to get through. So in the interest of just one, obviously we already covered, it's going to be less expensive.
Right.
But then in terms of just the time and how long you're going to be going through the process, I would think that collaboration or mediation would be faster too, right?
That's absolutely correct. Civil cases, which any family law case is a civil case between two parties, do not get precedent in or preference in the courts. All the criminal cases have to be heard first. And it is not uncommon for a divorce case, a custody case, a modification of custody to take at least a year before they're heard. Sometimes it's a year and a half. So it really does speed things up if an agreement can be reached, because I have had situations where we've been set for trial and we find out that the day of trial that there are no judges to hear the case, and we get bumped 4 months. So you never know what you're going to get when you go to court.
That's crazy. So Cary, thank you for your time. I've put a link to Cary's website in the show notes. Cary, would you mind sharing with the viewers the best way to reach you?
Absolutely. You can always contact me through the office. Phone number is 410-884-4049. Also on the website, which is jacobsonfamilylaw.com. You can actually go onto the website and make an appointment for a consultation at a time that is mutually convenient.
Awesome. Thank you again, Cary. Have a great day.
Thank you. Thank you for having me.